Definition of agreement. A formal recognition agreement forms the framework for industrial relations within a company. It outlines the rules and processes that the union and the employer will follow in conducting out consultation, collective bargaining, and representation. A recognition agreement identifies the union with the authority to engage and deal on behalf of employees at the workplace. It will state if a specific union has exclusive bargaining rights for a bargaining group or whether the company acknowledges two or more unions together. What should a recognition agreement include? The content of recognition agreements will change depending on the organization's size and type. However, all agreements should include the following clauses. First, the agreement's objective. Second, basic concepts. Third, the authorized labor unions. Fourth, the agreement's scope, which group of employees are covered by the agreements for the aims of discussion and consultation. Fifth, the representation structure, trade union representative, and the organization of the forum on which they will sit. Sixth, facilities. And the seventh, conflicts, meetings scheduled to resolve group disputes, and evaluation and termination of the agreement. Objective of collective bargaining. First, to achieve of collective agreement. Second, to protect workers' rights by including provision to check any abuse of power by the employer and prevent him from acting unjustly. Third, to allow workers to participate in decision-making in areas which are vital interest to them.
So, Havani already explained about the definition of recognition. So now I will jump straight into the condition of recognition. Well, the IRA does not specify them. However, a number of conditions have to be satisfied by a union before it can be recognized by an employer. A few conditions that I can state are: the union must be registered union. To simplify, it must be registered as a private sector employee union under the law governing the registration of unions with the TUA. Next, the union must be competent to represent the employees concerned, so that the union must be a blue-collar union and the employees must be a blue-collar employees, and the union must be confined by its constitution to the same establishment as those employees. And lastly, the union must be a representative of the employees concerned. So to put it as simple as I can, a simple majority, 50 plus 1 of those employees either must be members of the union or must want it to be represent them for a collective bargaining purpose. So before this, I did state that it does not IRA does not specify them, but the Act declares that if a union satisfies all the conditions aforementioned, then the employers shall be deemed to have accord recognition to the union from the date on which it served its claim for recognition on him. But if the union does not satisfy the conditions, then it shall be deemed that the matter has been resolved with the union not being accorded recognition. So at the end of the day, a blue-collar union which satisfies all the conditions has the right to recognition, although it is legislated by the IRA as a white-collar union, may not under the Act seek recognition. Such a union can have a right to recognition. So next, I will explain about the most important part, which is the recognition process. This is where all the steps and all the procedure will be told. So under the IRA, a blue-collar union may serve on an employer or employee union at any time a claim for recognition in respect of all or any class of the blue-collar employees employed by him. The claim must, however, be served in writing and in the prescribed form. So, whoever the employer upon who the claim is served has a number of options available to them, they may, for example, accede to the claim and accord recognition, in which case, of course, the matter is resolved. They also need to pay, they also pay, reject the claim, or even ignore them, in which case the union can file a written complaint with the Director General for Industrial Relations, or they may simply request the Director General to ascertain whether or not the union satisfies all the conditions for recognition. So after receiving either a request from employer or any complaint from an union of the sort described, the Director General is authorized to take such steps or make such inquiries as he may consider necessary or expedient to resolve the conflict. They also may permitted to seek the assistance of the Director General of Trade Unions in order to ascertain whether or not the union satisfies all the conditions for recognition. So the latter will know whether the union is registered and competent. So to determine how representative of the union is, one of the two methods is resorted to by the Director General, namely the membership verification exercise, or the secret ballot method. So the first method determines the percentage of employees who are members of the union, and the second method determines the percentage of employees who want the union to represent them for a collective bargaining purpose. So the industrial court has commented on both methods as follows. And lastly, what is the effect of recognition? So the IRA stated that once a claim for recognition has been made by a blue-collar union on an employer in respect of all or any class of the blue-collar employees employed by him, and while it is pending, the employer cannot declare a lockout against his employees or terminate any employee, although he may dismiss an employee on disciplinary grounds. Next, the employees cannot picket or go on strike against the employer for any reason whatever. And lastly, no other union may either make a claim or for recognition or be accorded recognition in respect of the same employees of class of employees. So I hope with this explanation, we can have a better terms of union so that it can function effectively for the workers. Thank you.
Condition of recognition case example: Korea Development Corporation against Construction Workers Union. The law and procedure on union recognition is perhaps not usually known. A union may organize the employees of an employer who are eligible for membership in accordance with the rules of the union. When it believes that more than 50% of the employees have joined up, the union claims recognition from the employer. On receipt of the claim, the employer might either accord recognition or apply to the Director General of Industry Relations for membership check. This membership check is carried out by the Director General of Trade Unions and for purposes of determining whether the majority of the employees of the employer are members of the union. The date of the claim for recognition is the date used. It does not matter if at the time of the membership check, some employees had resigned from the union or that more employees had been employed by the employer. Once recognition has been accorded, the recognition stands for so long as the union exists. Even though only one employee of the employee is left as a member of the union in this case, the decisive date for the membership check was 29 July 1981. The membership check was made in respect of all the employees of the employer, then employed except those employed in the above-mentioned capacities. Furthermore, the claim for the recognition was made in respect of the all employees employed by the employer, except those employed in a managerial, executive, confidential, or security capacity. And the Director General for Industrial Relations did not further limit the union's scope of representation. A union can represent only those employees who are eligible for its membership. Thus, one union can represent all the employees in establishment, or several unions may represent different classes of employees in the same organization. It all depends on the membership rules of each particular union. Any question to the scope of representation of a union is entirely a matter for the Director General of Industrial Relations and the Minister to decide under Part 3 of the Industrial Relations Act. The effect of recognition case example. In Hang Chiang High School against National Union of Teachers in Independent Schools, the school raised issue that the union had no local standard to represent the teachers in a trade dispute over a collective agreement, as none of the teachers now in the school is a member of the union. In Reading and Sedian Berhad against Sarawak Union of Land and Offshore Drilling Workers, the court held that as the company had closed down and all its employees had left its service, the union had no local standard as it did not represent anyone in the company in the trade dispute between the company and the union over a collective agreement. The court examined all the decisions on the local standard and summarized the principle as follows. It has established that once a union has been accorded recognition by an employer, there can be no question of the local standard of the union to negotiate a collective agreement on the ground that the majority of the employees are no longer members of the union, or that there is only one union member in the establishment. But if it is found after the reference of the dispute over collective agreement to the court that there is no union member at all in the establishment, then the union has no local standard in the matter. It is true that here the school has not closed down. It is still in operation, but at present without any union member, as all the teachers who were members had either resigned from the union or had left the school because their contract were not renewed. But can the union represent in a trade dispute over a collective agreement teacher who are not its member or no longer its member? On the principle initiated in Award 107 of 1987, we are of view that it cannot. It has no local standard to do so.
First of all, I think it should be mentioned the objective of collective bargaining. First is to achieve a collective agreement. Second, to protect workers' rights by including provisions to check any abuse of power by the employer and prevent him from acting unjustly. And last but not least, to allow workers to participate in decision-making in areas which are vital interest to them. And collective bargaining procedure was stated under Section 13, Subsection 1, 13, Subsection 2, 13, Subsection 4 until Subsection 6. Under Section 13, Subsection 1, where a trade union of workmen has been accorded recognition by an employer or trade union of employers. First, the trade union of workmen may invite the employer or trade union of employer to commence collective bargaining. Or second, employer or trade union of employer may invite the trade union of workmen to commence collective bargaining. That is under Section 13, Subsection 2, the invitation under Section 13, Subsection 1 shall be in writing and shall set out the proposals for a collective agreement. Section 13, Subsection 2A, a proposal for a collective agreement may provide for one or more of the following. First, provision for training to enhance skills and knowledge of the workmen. Second, provision for an annual review of wage system and provision for a performance. Under Section 13, Subsection 3, no trade union of workmen may include in its proposal for a collective agreement regarding of the following matters. First, the promotion by an employer to any workman from lower grade or a category to higher grade or a category. Next, the transfer by an employer of workmen within the organization of an employer's profession, business, trade or work, provided that such transfer does not entail a change to the detriment of a workman in regard to his terms of employment. Also, the employment by an employer of any person that he may appoint in the event of a vacancy arising in his establishment. And the termination by an employer of the services of a workman by a reason of redundancy or by reason of reorganization of an employer profession, business, trade or work, or the criteria for such termination. Furthermore, the dismissal and reinstatement of a workman by an employer. Last but not least, the assignment or allocation by an employer of duties or specific tasks to a workman that is consistent or compatible with the terms of his employment. Next, under Section 13, subsection 4, employer or trade union of employer or trade union of employee who has been invited under Section 13, subsection 1 must reply to the invitation within 14 days. Also, under Section 13, subsection 5, where a reply notifying acceptance has been given, the parties shall commence collective bargaining within 30 days from the date of receipt of the reply. Next, under the Section 13, subsection 6, where an invitation to commence collective bargaining has been made and the invitation has been refused or not been accepted within 14 days, or where no collective bargaining has been commenced within 30 days from the date of receipt. Under Section 13, subsection 6, where an invitation to commence collective bargaining has been made and the invitation has been refused or not been accepted within 14 days, or where no collective bargaining has been commenced within 30 days from the date of receipt, the party making invitation may notify the Director General of Industrial Relations in writing, and the Director General may take such steps as may be necessary or expedient with a view to bringing the parties to commence collective bargaining without undue delay. Moving on to the collective agreement terms, under Section 14, subsection 1, a collective agreement shall be in writing and signed by the parties to the agreement or by person authorized in that behalf. And Section 14, subsection 2 state that it must specify the parties to the agreement. Second, it must specify the duration of the agreement cannot be less than 3 years from the date of commencement. Third, it must include a procedure for modification and termination of the agreement. And fourth, it must specify the procedure to be used to settle any dispute over interpretation or implementation of the agreement. For the deposit of collective agreement, under Section 16, subsection 1 IRA, a signed copy of the agreement shall be deposited by the parties with the registrar of the court within 1 month from the day on which the agreement has been entered into, and the registrar shall bring it to the notice of the court for its cognizance. Under Section 16, subsection 2, the court may, in its discretion, they may refuse to take cognizance of the collective agreement if the collective agreement does not comply with the Section 14. Before taking cognizance of collective agreement, the deposited shall be amended in such manner as the court may direct. Under Section 16, subsection 3, if any party to the collective agreement fails to carry out such direction, the court may amend the copy after giving the parties a reasonable opportunity of being heard. Next is the effect of collective agreement. Under Section 70, subsection 1 IRA 1967, a collective agreement which has been taken cognizance of by the court shall be deemed to be an award and shall be binding on, first, the parties to the agreement, including any case where a party is a trade union of employers, all members of trade union to whom the agreement relates, and their successors. Second, binding on all workmen who are employed or subsequently employed in the undertaking or part of undertaking to which the agreement relates. For the related case, Kesatuan Kebangsaan Wartawan Malaysia and Enor versus Syarikat Pemandangan Sinar Sdn Bhd and Enor Federal Court state that it is whether binding on successors, assignees, or transferees of union of employers to whom agreement relates, according to the application of Section 70, subsection 1. Under Section 70, subsection 2 IRA, as from such date and for such period as may be specified in the collective agreement, it shall be, first, an implied term of the contract between the workmen and employers bound by the agreement that the rates of wage to be paid, and second, the condition of employment to be observed under the contract shall be in accordance with the agreement unless varied by subsequent agreement or a decision of the court. That is interpretation and variation in collective agreement. Under Section 33, subsection 1, if any question arises as the interpretation of any award or CA taken cognizance of by the court, Minister may refer the question, or any party bound by the award or agreement may apply to the court for a decision on the question. Under Section 33, subsection 2, the court may, upon the application from any party by order, to vary any of the terms of an award or agreement if it considers desirable so to do for the purpose solely of removing uncertainty. As for the related case, the National Union of Hotel, Bar Restaurant Workers, Peninsular Malaysia versus Tanjong Jara Beach Hotel Sdn Bhd, where the Court of Appeal is in Kuala Lumpur, and the award is the employer attempting to evade obligations under collective agreement. The award made against the employer and the industrial court acting in accordance with the well-established principle of industrial law and equity. Next is under Section 30, subsection 5 IRA, the industrial court shall act according to equity, good conscience, and substantial merits of case without regard to technicalities and legal form. Next is for the non-compliance of collective agreement. Under Section 56, subsection 1, any complaint that any term of any award or any CA which has been taken cognizance of by the court has not been complied with may be lodged with the court in writing or by any trade union or person bound by such award or agreement. Next is under Section 56, subsection 2, the court may make an order directing any party first to comply any award or collective agreement, or second to cease from doing any act in contravention of any term of the award or collective agreement. The third, to make such order as it deems fit to make proper rectification or restitution for any contravention of any of such award or collective agreement. The fourth, make such order as it consider desirable to vary or set aside upon special condition any terms of the award or collective agreement. As for the related case, Prestige Ceramic Sdn Bhd versus Kesatuan Pekerja Pembuatan Barangan Bukan Logam and Enor, 2001. In Section 56, the non-compliance with award or collective agreement, the High Court held the financial incapacity of the respondent could constitute special circumstances and that the industrial court had to look at the causes of the financial incapacity. Next is the effect of non-compliance of collective agreement. First, trade dispute. Second, picketing. Third, strikes. And fourth, lockout. As for the example of collective bargaining case, in Section 13, subsection 3 IRA, where the Download Malaysia Industry Berhad versus DMIB Employees Union, which award 235 of 1986. The observation of Hashim Yub Sani J in All Malayan Estates Staff Union versus Malayan Agriculture Procedures Association in High Court, that the item in Section 13, subsection 3, A to the F are absolutely prohibited from being included in the proposals for a collective agreement. Do not apply here. It would be in order to include any of the items under Section 30, subsection 3 in a collective agreement if it was the employer that brought out the item for inclusions. Hence, depending on the employer involved, anything connected with the employment of blue-collar employees may be bargained upon, and nothing affecting the relations between employers and blue-collar unions is outside the scope of bargaining. That's all.